Technical Assistance Director for the Rocky Mountain Employee Ownership Center in Denver. We work statewide, and I'm also a CU alumni.
And we have one more.
Michaela?
Hi, my name is Michaela Holmes. I'm the Cooperative Development Co-Director at the Center for Community Wealth Building. And we do co-op development, mostly startups, and we're just starting to work more broadly, but in Metro Denver and other metro areas in the state.
Fantastic. Thank you all for being here. It is much appreciated, especially with some of these new ideas around the co-op space. So we're going to start off with David. Why don't you go ahead and kick us off?
Sure. So I did note Stan's point about saving questions to the end. So just feel free to kind of, typically with talking about entities, you get lots of questions. So just keep track of that and we'll cover what we can at the end with questions. I'll do a screen share here as well. So one of the key things that's relevant when you're starting a business is forming an entity. You actually create a business entity to conduct operations as a business. And there's lots of different kinds of entities. And one of the things that we do as lawyers is help entrepreneurs figure out what makes the most sense to, kind of start their venture, right? And so just echo what Stan said, you do want to be, generally speaking, pretty early in the process. You want to form an entity to conduct business under. There's a variety of reasons to do that. We'll talk a little bit about that. The main reason, well, there's probably several, but one of the main reasons you want to form an entity when you're going to conduct business, for one thing, there's a concept called limited liability. If you are conducting business operations through a legal entity, in some respects, it can provide potentially meaningful protection for your personal assets. So if the business signs a contract, if the business sells something and somebody gets hurt, something goes wrong, something gets damaged, in theory, if the business has done stuff right, it might be that the business entity could be liable for whatever losses or problems arise. But if you've done it right, you personally, as the entrepreneur, the founder, the person that runs the business, in theory, you shouldn't be liable if it's a business problem. So it can be protective of your personal assets. It's not worth spending too much time on that concept, but just keep in mind, fundamentally, conducting business through an entity can help you protect yourself and save yourself personally if your business has any issues. Another big part of it is that it's not simply about liability. It's about positioning yourself well to both be successful as a business and operations. And as is often the case, if you have to raise money, you pretty much need to have an entity to be able to raise money. Lots of companies need funds for lots of reasons. It can be loans, it can be investment from private investors, it can be government grants, it can be all sorts of stuff. Entities are a great way to help you do that. So there are other entities here, and I know that the calendar invite for this event also refers to a couple other entities that personally I won't spend quite as much time on, but we can talk about in kind of high level. For most startup ventures, I would say most of them, and there's always exceptions, most of them typically take one of two forms. The first form is called the C corporation. We'll talk more about C corp, S corp, and how that can vary. But a very typical vehicle is to form a corporation. The second most typical vehicle, I would say, is what's called the limited liability company, which you see a lot of, especially in Colorado, and especially in, at least what I've seen, in regions outside of like New York and the Bay Area. Lots of startups that I've worked with seem to start out as LLCs. There's a few other entities to talk about too. There's S corps, there's co-ops, there's B corps. A pretty big part of my practice focuses on startup work. So helping emerging growth businesses get started, raise money, sign contracts. And I would say, in my own experience, easily over 90% of the companies I work with in Colorado and elsewhere in a variety of industries, they almost always fall into either the LLC or the corporation entity. There are other, things out there, but I would say the bulk of the time, most startups form as either an LLC or a corporation. what I typically say, so we'll kind of just briefly explain the corporation. It's the typical entity that a company will start out as, or a business will start out as, if it expects to raise venture capital. Obviously, in Boulder, especially, there's lots of companies that want to raise VC capital. Being a Delaware corporation, and I do deliberately say Delaware, most companies that plan to raise venture capital pretty much always will want to be a Delaware corporation. So it's the typical entity you do if you want to raise money from VCs. High level, there's no limitations on the kinds of owners that a corporation can have. It can be individuals, it can be other entities. You can have different classes of stock. You can have preferred stock or common stock. Typically, in a C Corp, and C Corp versus S Corp, just very briefly, they're both corporations for state law purposes. An S Corp has certain tax treatment, a C Corp has different tax treatment. Most venture-oriented companies are going to be C Corps. But generally speaking, it's the most widely, it's a particularly robust form of entity. There's a lot of corporate precedent, especially in Delaware. So there's a degree of predictability around how corporations operate, how they're supposed to be governed. So they're kind of widely used. On the disadvantages, as far as like what are the cons of going the corporation route, typically a C Corp especially, it's got 2 layers of tax, meaning when the company has profit, the company has to pay tax. And if the company then distributes cash to its owners, the shareholders, there can be tax at the shareholder level. So a C Corp has 2 layers of tax. There are other entities, LLCs being a good example, S Corps, that only have 1 layer of tax, but there's other kind of pros or cons to those. So don't get too hung up on the details for purposes of this type of a session. I think the main thing to think about here, the key takeaway on the corporation point would be most typical for companies that want to raise venture capital. Most of the time being a C Corp is going to make more sense. There's plenty of examples of S Corps. That's a lot more complex to get right. It's also easy to screw up. So I'll just kind of leave that at a high level. We can talk more if there's questions on it. And by the way, I'll kind of pause for a sec. Stan, I'm kind of trying to strike a pace between too fast and too slow. So if you think I'm moving too quickly or too slow, just feel free to chat me or let me know. I want to try and be respectful on time. As far as LLCs, that's the second kind of entity that most startup ventures will start as. It's got this flow through tax. So I described kind of the C Corp thing where you got entity level tax and then owner level tax. For LLCs, they're typically taxed in what's called the partnership form, which is 1 layer of tax rather than 2 layers. That's a tax advantage for the LLC. There's no limit on the type of owners. You can have all kinds of different equity in an LLC. You can have founder equity and investor equity, just like you can have in a corporation, and even with more flexibility than you can have almost too much flexibility in an LLC. That's one of the reasons they can actually be kind of complicated for startups. You can have lots of flexibility in how governance works, how decision-making works. You can frequently limit fiduciary duties in an LLC a little bit more so than a corporation. So the key concept with LLCs, as far as the advantages, I'd say the 2 primary points would be usually a little bit more tax optimized compared to a C Corp, and then tons of room for flexibility in how you do your economics and your governance. But that's a double-edged sword. We sometimes say that as many startups as form as an LLC, it's actually the classic scenario where LLCs often work can be very complex. There's so much flexibility with an LLC that they're kind of adult companies in the sense that you can almost have too much flexibility and it can get really complicated to draft it correctly. So I would say to kind of take a step back and be practical for a second. Lots of companies come to us and say, hey, we're 3 founders, we've got an idea. We don't really know if we want to raise venture capital or not. Maybe we do, maybe we don't. Should we be an LLC? Should we be a C Corp? Should we be something else? When you look under the hood on this stuff, there's lots of pros and cons to any choice you can make. My typical rule of thumb is if you're relatively confident that you want to raise outside capital, particularly from like a VC fund or an angel investor, probably starting as a C Corp makes the most sense. If you're really not sure and it feels like it's a coin toss whether or not you'll actually want to raise VC, maybe you'll just make a go of it on your own. It's not impossible to start out as an LLC and convert later. There are some complexities to that. But particularly if it's just a handful of founders without significant capital raise needs and an uncertain future, the LLC route can work pretty well. And then a couple other things to mention. Really, regardless of whether you're going to go down the corporation route or the LLC route, it's not particularly expensive to form, either entity. Delaware is kind of the standard jurisdiction for corporations in particular. You'll probably spend there's always going to be at least several $100s of fees that you have to pay to the state of Delaware, or for that matter, the state of Colorado, to form an entity. So it's just to create the entity in the first place is always at least a few $100s just in state filing fees. It's not very difficult to do, though. Separate from the actual filing fee to create the entity, you want legal documents to create the thing and build your kind of founders agreement around it, right? So, and I kind of say that loosely. Legal fees, if you're working with a law firm that knows startup work, it should never be particularly expensive unless you're doing really customized, really unique terms. You want to keep stuff pretty simple and pretty vanilla for a startup type company when you're getting out of the gate. So, I would say separate from several $100s in legal fees, several $100s in filing fees, you're typically looking at, I would say very broadly, somewhere between $1,000 and $3,000 in legal fees to work with a lawyer to help you actually put the documents together. Some firms will do it for less, some will charge you more. Typically it shouldn't be much more than that, but to get it right, typically takes at least some measure of, some work from a lawyer that knows what they're doing to help you get your documents put together. Also, one other thing to mention, I kind of mentioned this a minute ago, but it bears emphasis. Particularly in Colorado, I've seen this a lot over the years. We're seeing lots of founders. I've got several clients right now that are dealing with this. They form an LLC themselves. They don't even work with a lawyer, and that can work. You can form an entity and don't need a lawyer to do it. But they'll come to us and say, hey, it's just me. I'm the solo founder. It's me and my two co-founders. We formed an LLC. We don't have an operating agreement, or the operating agreement sucks and needs to be fixed. But what will often happen is they'll say, we formed the LLC, but don't have good documentation, or we formed the LLC and now we're talking to an angel investor or a VC fund. They're saying we have to convert to a corporation. To actually convert, and it's a technical thing that you do want to work with a lawyer for this for sure. You can convert your LLC into a corporation. That's going to be several $100s in state filing fees again, but there's actual technical documentation that you need to get right to properly do your conversion. So that's one area where I would say, just like I said, it's typically, depending on the specifics, somewhere between $1,000 and $3,000 to get good legal help in creating an entity. You're probably looking at, I would say, somewhere between $1,500 and $2,500 to do a really simple entity conversion, but it is possible to do that. So what I would say is it's very typical, or it's very common, that we see a startup LLC convert to a corporation as part of a financing, for example. It is significantly less typical to see a corporation convert into an LLC. I think it is technically possible, but I've actually rarely seen it. It tends to be a lot more complex and doesn't make as much economic sense to do. So, that's something to keep in mind. So let's see. There's a few other kind of quirks. I'm seeing this question come up a lot in the last couple years. And it's specifically when you get kind of this startup LLC, and the founders will come to us and say, hey, we're an LLC. We want to raise money. We don't yet want to do a large investment round from a venture fund. We want to raise a few $100,000 with convertible notes or simple agreements for future equity. You maybe heard of SAFEs. what safes and convertible notes are, just really high level, they're not actual share ownership. They are an investment contract, basically, that says the investor's giving the money now, but the note or the safe, as the case may be, will convert into ownership down the road based on future events happening. The typical main thing is if there's a subsequent financing transaction where the company raises capital, that subsequent financing transaction will cause the safe or the note that's already outstanding to convert into equity. And I kind of tried to shy away from this whole topic in presentations like this years ago because it's a little technical, but it's coming up more and more. So I think it's important to at least briefly mention.
Well, I do think, Dave, and correct me if I'm wrong, Stan, but I do think part of the prize this year is in the form of a safe note. So it's,
that is correct, and that's why we have a specific workshop on funding later this spring.
Yeah.
Sorry to interrupt you.
And yeah, so what I'm saying is, and I appreciate, and I forgot about that new feature. In my day, I sound old now, we didn't have safes for the NVC, so it's cool to see the progress. But what I would say is, it's relatively common that we'll have a startup LLC, it'll raise money via safe, and then as part of a subsequent equity transaction where the investors put money in for actual share ownership, as part of that subsequent financing, the LLC will convert to a corporation, and after it converts to a corporation, the safe will convert into ownership. That tends to give us a little less concern, but I get a call just yesterday with my tax partner and a client who's looking at this in real time. We have a client that's an LLC, it's conducting business, it's got real revenue, it's a real business, there's real money flowing through the thing. They are an LLC. They are considering raising money via safe and potentially converting that safe into equity ownership, several months down the line while they remain an LLC. That's the thing that will almost certainly cause potentially very expensive tax and accounting consequences. Partnership tax is way complicated. It's even beyond my pay grade, to be honest. But what it basically means in substance, if you're an LLC that has raised money via safe or convertible note, and that safe or note is going to convert into ownership while you remain an LLC, it can trigger what's called a capital shift, which can create potentially significant tax consequences for all of the owners of the LLC. So I think it's important to kind of emphasize that I'm not saying that you can't raise money via safe or note as an LLC. Plenty of companies do. Where you want to be cautious and careful is ideally not converting that safe into actual equity ownership until after the entity's converted to a corporation. So if I'd say, if nothing else, just kind of remember safes and LLCs, you got to be careful and think through when you would expect that safe to convert into ownership. That's one that it comes up so frequently that it's often, I've told a handful of clients or potential clients in recent years, you might end up making your life easier by just doing the corporation because safes tend to complicate the LLC capital raise dynamic. So
Dave,
the short answer is, yeah, go ahead.
If I can jump in real quick, because one thing I want to put caution on here is we've got 86 teams competing, and only 2 teams are going to walk away with a safe investment at the end of the day. And so for them to think about, wait a minute, I got to invest $1,000 to $3,000 to create a company right now, and I don't even know if I'm going to win. Is it safe to say that these ventures right now could look at creating an LLC, which it only costs $50 to do the filing, and there's online tutorials on how to do the paperwork on your own, where you don't necessarily have to go through the legal process, so that it's at least an entity, it's formed. But then if they win that safe, it's still okay as long as they create that C corp before there's an equity shift. Am I good there?
That's a high level accurate description. And yeah, and I do think it's important to emphasize that. I know that every time a lawyer talks, people start wondering about the fees that they have to pay for it. You can form an entity yourself in Colorado. You can form a Colorado LLC on the Secretary of State website. It takes probably 10, 15 minutes at most. And you don't even technically have to draft other documents for it. You don't need a lawyer to form the LLC. There's other stuff we'll talk about here in a minute that you want to at least be aware of. But yeah, I think that's an important point, Stan. You don't need to, there's nothing that says you have to hire a lawyer to form an entity. And you don't need to worry about spending money that you don't have or that, you don't want to go have to find at the really earliest stage. But I'd say even then you do want to form the entity if nothing else. That's a good point. So regardless of whether you form an LLC or a corporation, what's really important, and you'll kind of see this box here on this box on the bottom right corner of the slide, you kind of think of the entity as a box and what is supposed to go into the box. And this is important, not just, even for companies that know they don't really want to raise much or any money from outside investors and just want to self-fund and try and grow from revenue, regardless of what your plans are for investment. You think of your entity as a box, and in the box goes intellectual property. So what does that really mean? If your founder team or the founder team plus other people you might hire, if you're all working on an idea or a business, regardless of whether it's a product company or a service company, tech or food or you name it, it doesn't really matter. Generally speaking, when the co-founders, the employees, the whoever, when they're working on the venture together, it's essentially inevitable that some kind of intellectual property is going to be created, whether it's copyrights or trademarks or patents. Don't even get too hung up on that for now. Just think of it as ideas and processes and know-how. Stuff's going to be created. And a particularly easy example could be maybe it's some special process that didn't exist before. Maybe it's a patent. Maybe it's, you just think of a logo for the business. There's all kinds of ways IP can be created. And by having a legal entity, all the co-founders, all the personnel can essentially transfer or assign to the entity itself all the intellectual property. That's important because if the legal entity doesn't own the intellectual property related to the business, if the individual co-founders each separately retain it and say, I never assigned it to the company, I was just letting the company use it, or I was letting the business use it, the company itself is not really worth anything, or it's certainly worth a lot less. It can make it a lot harder to raise money. It can make it a lot harder if somebody wants to leave the business and there's confusion about, well, does the departing co-founder own the IP? Does the business? There's all kinds of ways in which problems can arise if the legal entity itself doesn't actually own the IP. So there's a million ways you can do it. And I appreciate Stan's point about being cost conscious and not over lawyering this stuff. If nothing else, even if you don't work with a lawyer, you probably want something somewhere among the co-founders that says they assign their IP rights in the business to the entity. Now, obviously, lawyers will help you with better and more extensive documentation of that. But if you're aiming to be particularly light on your spend and your expenses as you start out, which makes sense, plenty of companies don't want to overspend too quickly. If nothing else, you want to kind of be mindful of that concept that you want your entity, the business, to own the IP, not the co-founders individually. That can get into all kinds of problems if it's not done right. That's particularly for the co-founders. Another thing entities do, in addition to owning the IP of the business, is they'll sign contracts. So rather than Dave or Chris personally signing a contract, if Dave and Chris form an entity for our new business idea, and then we go sign contracts to buy stuff or sell stuff, or just have a conversation about a potential transaction, and we sign a non-disclosure agreement, you want to do it in the name of the entity itself, rather than having the individual person. Now, people still sign contracts, but they sign them typically on behalf of the entity itself. So that's something to kind of keep in mind. Kind of been droning on for a few minutes here. Stan, I'm not sure if you want to pivot to the other participants. I know I'm sure there's probably some questions on the entity specific stuff. I kind of wanted to keep it high level as we just started. I think the key takeaways would be it's likely LLC or corporation. The LLC is the cheapest and fastest. You can convert it later. You want to assign IP to the entity. That's kind of a really high level.
That's perfect. Yeah. So let's shift over to some of the other options.
Sure. So a couple other things you'll see, and I know in the subject line, there's the reference to co-ops. Actually, Dorsey, the firm that Chris and I work with, actually does a ton of work in co-ops. They're a very different animal. I'm not sure if Michaela would want to speak on that at all. I would say in the startup space, I rarely see them. I've had a few clients deliberately try and do the co-op thing for different reasons, but a co-op's a bit of a different model. It's frequently one where, like, you think it happens a lot in food, where you might get like dairy producers. They all have, kind of dairy operations, or they might grow vegetables or whatever. There's all kinds of ways in which in food production it's very common. Co-op can be something where all the different people who are all separately doing stuff kind of combine forces and sell the goods through the co-op. That happens with, food and products of all kinds, actually. So my own personal experience with co-ops has been frequently in the food space. There are other examples of it, including with technology-oriented businesses. But to be totally honest, in my own experience, it's much more rare. That's not to say it doesn't happen. So my own personal experience is kind of limited there. Yeah, go ahead.
Yeah, that's the perfect segue over to Michaela. So Michaela, why don't you take it away and talk about co-ops?
Sure. This is Matt, actually. I'm going to share my screen and we'll do introductions in just a second.
Dave, can you unshare your screen so that he can jump into his screen?
Thank you.
Great.
All right. All right. Thank you so much, Stan, for having us, and to David and Chris for the first portion of the program. We're going to switch gears a bit and kind of pick up on that segue of looking at other companies that are deemed employee-owned in the state of Colorado. So first, we'll start with some introductions. My name is Matt Lucina. Like I mentioned, I serve as the program manager for the state of Colorado's employee ownership office. We're kind of adjacent to governor's office. We're situated in the Office of Economic Development and International Trade. And employee ownership is super strong here. We have about 35 to 40 cooperatives, like the structure that Dave was mentioning, and about 200 total employee-owned companies that we work to support. And we work very closely with Ashley and Michaela, so I'll let them introduce themselves.
Michaela, you want to jump in?
Yeah, I got it. Thanks. Yeah, I mentioned my name is Michaela and I work for the Center for Community Wealth Building. So as you can see, there's three of us. We run deep. We're really passionate about the cooperative model. And to David's point, it's like kind of at the heart of what we do is to make sure more people know about this and normalize it and say like, oh yeah, I could start as a co-op. So in my world, I see businesses start as co-ops a lot. And interestingly enough, we heard David mention, if you're a corporation, you're going to incorporate in Delaware. Well, Colorado is the Delaware of cooperative law. So we're going to just give you a little bit of an overview of EO. And I will have a very small in this presentation. So I just want to you guys know that we're here and excited about your guys' project. So thanks for having us.
Thanks, Michaela. And Ashley, I'll kick it over to you.
Yeah, great. So as I mentioned, my name's Ashley. I'm with RMEOC, and I'm going to do a quick overview of some of these forms and then try to leave a lot of time for questions, because just like David mentioned, the high level usually is helpful at the very beginning, but there's usually just very detailed questions. And Michaela and Matt and I will all be here for questions. So we wanted to start just with a broad definition of employee ownership, and various forms of EO have traced back all the way to the mid-1800s. So it's a very proven concept. And really what it means is that a broad base of the people that work in a company own a financial share of that company. So that's really what we're talking about. And then also to place this with what Dave was already talking about, or David, that this intertwines with these forms. So you'll see some of the structures that I talk about, like a cooperative, it can actually be an LLC or it can be a corporation. So we're not talking about something fully separate. We're just talking about different ways to integrate in the ways that employees can own that into these entities that you're already learning about. There's a lot of benefits to look at employee ownership, even when you're first starting out, and then through the life of the company. So some of the things we'll talk about are startups, and some are going to be ones that you might grow into. And then you can see here even some for succession planning, things you might look towards at the end of that company vision. Maybe you're looking to move on to create a succession plan, ways to preserve your legacy. But also, some of these benefits are about staying there. It doesn't mean you have to be leaving in order to change your company into an employee-owned company. You can stay, convert into these different forms, and have it be a way to reward and retain employees. And with most of these forms, there are tax incentives. Again, as David was mentioning, that's a lot of the strategy around which type of entity to choose. And just know that with starting up or converting to a form of employee ownership after you exist, there can be tax incentives. But overall, employee ownership is something you might want to look at to create a stronger and more resilient company overall. You can see here some of the statistics when worker co-ops or ESOPs, these are all different forms I'll talk about tonight, are compared to traditional forms. We see higher profit margins, faster growth per year in sales and employment. They're 25% more likely to stay in business. And then this note above, one thing I wanted to mention is that with some of these structures, there's, of course, the equity ownership piece, but some of them dictate that the employees actually have a democratic say in the way that company is run. And what we do see is that these statistics do even better when those things are combined. So you'll see, again, there's ways to do it where it's simply the equity that is more in the hands of the employees, but in some of the forms, the employees do have a democratic voice in the ownership level. So just keep that in mind as you're listening to these different forms and thinking about what might be a good fit. I think it's helpful to think about employee ownership in three main categories. There's alternative equity structures. These have lots of different forms. As I mentioned, they can be different types of actual entities, LLCs or corporations, but it's ways to do certain profit sharing plans, things like phantom stock, and put some of the equity into the hands of the employees. This is a form that can happen right from the beginning if you want it to, for any size company, and it's also something you could grow into. Worker-owned cooperatives is its actual own entity, and I'll go into each of these in a little bit more depth quickly here. Worker-owned co-ops are suitable for very small companies as well, for startups and or something to be converted into. Employee stock ownership plans, or ESOPs, are actually the most common form in the country, but they are appropriate for later term to convert into and grow into, and I'll talk about why that is in a minute. And then just a quick note here before I dive into the details about B Corps and employee ownership and or PBCs. These are both very good fits with employee ownership, so those are not things you have to look at as an either or. There are B Corps that are also cooperatively owned, things like that. Here's a couple of examples from around the country. Namaste Solar is a company here in Colorado. So again, just to keep that in mind, none of this is a separate path. It can all be overlaid into the vision and can really be this force for greater good. So quickly, alternative equity structures, as I mentioned, you can see here, there's lots of different ways to manifest this, and attorneys can very quickly help you figure out which of these might be the right fit. Just two examples of this: Palmer Flowers is a company in the metro area with several locations. They have what's called a stock option plan. And phantom stock model is another option. And there's a company, Sexy Pizza, you might be familiar with at least 5 locations now in Denver. They've implemented these forms, and it's a way to share the equity. This is one where once the equity is in the hands of employees at either 20% or more of the company, the state deems that company employee owned. So that's a threshold to keep in mind, the 20% marker. These ones do not have to have the democratic aspect in play, but you can pick and choose ways for the employees to be engaged. And the second category is this worker-owned cooperative. And in the state of Colorado, as Michaela mentioned, we actually have 2 statutes that govern and show you how you can actually create a worker co-op as an entity type. It can be a corporation or an LLC, and it's pretty rare in the country to have 2 actual forms now that you can look to. This is an entity type where that democratic piece, the employee voice, is actually built into the structure. The 2 things to keep in mind with this one is that workers do directly own the business and share equitably in the profits, and that decision-making is democratic, with each worker having 1 vote. But 2 things to keep in mind: that does not mean that everybody has a say in everything. We're talking only about that ownership level. You can still have a very traditional hierarchy of CEO, whatever kind of management system, but we're talking about the employees having a voice in that governance level of the company. And then another piece is that it does not mean that every worker in the company has to be an owner. So a worker-owned cooperative can be owned, say, by 3 members of that business, even if there are, say, 15 workers, and those other 12 might have a pathway eventually to become an owner, but it does not mean that everyone has to be an owner. As I mentioned, they're good for any size company, and they're a relatively low-cost form to start up. And these numbers, the 10 to 25, would be for a conversion. The actual, if you start up from scratch, it's going to be more in the realm of what David mentioned, several thousand. But that would be if you have a company later on that you've built up to, you might be looking at those sorts of costs to actually convert that company into a cooperative. And this is example, again, I mentioned Namaste Solar, both in Boulder and Denver. They're one of the largest co-ops in the country, and they've had between 1 and 200 workers, and making this work, where everybody does have a voice in the governance of that company. And as David mentioned, also there's different types of cooperatives where people are coming together to share in products or purchasing. What we're talking about tonight is a very specific kind of cooperative that is called a worker-owned co-op. So you'll hear the term co-op much more broadly, but we're talking about one form where the workers actually own the entity. And so this third category, ESOPs, again, something to look to for the future, but a really great form for the company to grow into. In an ESOP, employees actually own shares of the company through a trust, and the company's making contributions into that plan, typically based on a % of wages. Most advantageous for larger companies. It's pretty expensive to set up. As you can see here, 75 to maybe 150,000. Has tremendous tax benefits, though, for the owner who is selling and for the employees. Stone Age is a little example I put down there at the bottom. They're in Durango, really great example here in Colorado. And here's a few just logos, companies that are employee owned you might be familiar with. These are all different forms. And then here's a quick pathway. If you're thinking about exploring this, any of us can help you with this path exploration. Then you do an assessment, then the actual structuring. just like David was talking about, where you're setting up the entity to actually execute it, and then you'd move into a support realm. And I'm going to pass it along to Matt here to talk about some funding that can help you pursue these paths.
Thanks, Ashley. I'll keep this quick so we have time for some questions and dive in a little bit more. Colorado has kind of been a pioneer in terms of providing state funding support for these conversions or formations. Right now, we have the Employee Ownership Tax Credit Program. It is $10 million a year for 5 years to support the conversion of eligible conversions of companies to employee ownership. Worker cooperative is one of 11, a non-exhaustive list of 11 structures that we actually seek to support. So for co-ops, that could be up to $40K per application. For ESOPs, that would be up to $150K. And then newly, we're allowing applications for expansion. So sometimes companies will set up like an alternative equity structure, and then they'll shift into something like a worker cooperative, or they'll do a partial worker cooperative and then shift to a full. Now, actually, Colorado, again, another first in the country, we have support for that type of conversion work that's occurring in our state. And also, we're working on a new bill right now. We're actually doing testimony tomorrow at the House. We're going to be, we introduced recently a bill to support these companies in an ongoing sense as well. That's another first that exists nowhere in the country. So Colorado's kind of remains kind of the premier employee ownership office in the country. And I just wanted to briefly share our educational program that we released. It's an online modular-based learning. It's basically helping to reduce the gap in knowledge between the business owner or entrepreneur and someone like an Ashley or Michaela or a David when they're kind of working with their clients. So it's a quick 45, 50-minute click-through process. It's free, available whenever you want to access it. So the link is there. We can share these slides after, or you can reach out to any of us to learn more. So we're just continuing to advocate and educate business owners on the benefits of employee ownership and some of the programs that can help support them converting their company to employee owned. So again, here's all of our contact information and websites, and we'll stop talking at you so we can engage in the discussion if there's any questions.
That was awesome. Thank you, guys. And yeah, so we just finished drinking from the fire hose of company formation. And let's do this. If our speakers could go ahead and throw their contact into the chat, that way, if we run out of time, people know how to get a hold of you for further questions. That would be fantastic. We're also recording this, and we will work on getting it online for people to come back and look at if they need it later. But let's jump into questions right now. So who's got some questions? I don't know where to start.
That's not a question.
My name is DJ. I might have a question here. I am thinking about the requirements in NVC with creating a team agreement where it would list out the potential founders or that would potentially move on with the company. And I wanted to understand maybe more of a relationship between that. Like, what if there are more founders listed on the team agreement? Does that necessarily mean that in a creation of a company, do all members of that on that agreement need to be within the new company or the actually established company?
So I'm not sure what the NVC specific rules would be, but generally speaking, being a co-founder doesn't automatically mean that co-founder A owns the same amount of the business as co-founder B. Those things can be really highly negotiated. So, Stan, I'm not sure if there's NVC specific guidelines on what stuff has to look like. But legally, co-founder can mean all sorts of stuff, and there can be all kinds of ownership splits among the core group.
Yeah, I can speak to that real quick. We do require a founder's agreement, but it is up to those participants to decide what it looks like. So, you know, we just think it's important for them to think about it and put something in place so that hopefully that mitigates some issues that might arise without it. But it really truly is up to you guys on what that looks like.
I'll just add to, I know this wasn't exactly your question, but it's kind of relevant for the programs that we were speaking about during our portion of this engagement. We have to define employee ownership for eligibility criteria for our programs, and some of this is done in statute, and some of this is done by my agency as part of, you know, they're like the ruling authority for this program. So for employee ownership, we say the agreements have to be that there's, you know, at least 3 members of a cooperative or 3 participants to the employee ownership structure. And that for a conversion, if a company is changing their structure to employee ownership, there's at least 20% equity that's shared amongst those three or more employees. So those are the 2 kind of conditionals that we look at for eligibility. And for the startup space, you know, often if stock options are granted, or if there's kind of a new company incorporating this at the start, sometimes it's right below that 20% threshold. So, you know, 20% is a low barrier compared to like a lot of the federal definitions for employee ownership. It's usually majority. But we, you know, 20% is what is kind of set in stone for all of our programs.
And DJ, I'll just say one more thing. Whoops, I actually did it. Sorry, I did it just to David. Everyone, here we go. Here is, you know, there are a plethora of examples of what a founder's agreement will look like, but here's one in the chat that I just put in there, and that is from UPenn. So just something that you can look at. But again, it's up to you to decide what that founder's agreement is going to look like. Other questions?
Dave and I both went there.
There you go. So it's legit.
Yeah.
I had a question about like the assignment of intellectual property for things that have already been done. Our group sort of spun out of a class project. So is there some standard way we should word that to sort of capture the things that were done in class are now being assigned, or how does that?
I mean, there are, yeah, I'll take this one. You know, I'm the patent attorney. There are some things you want to have in an IP agreement or an IP assignment to the company that are standard, but you can also tweak it depending on the situation. So typically, I mean, under U.S. law, the inventor of something that is, if we're talking about patents, and the assignments are going to look different whether you're assigning copyrights, trademarks, or patents. There's some specific things about each one of those. But if you're assigning a patent, the inventor is the person who sort of had the idea, like the spark of genius, right? It's not the legal term, but that's sort of the person who came up with, not somebody who reduced it to practice. Like you had an idea, but then for a new machine, and then you had somebody do the CAD for it. They're not necessarily the inventor. You know, you're the inventor. So that's sort of the first question to ask is who is doing the assigning, right? And then and that's usually the most finicky part to tease out is who's the inventor. And then once you get to there, then the language to assign it to the company is, like I said, it can be fairly standard, but it can be tweaked depending on the situation.
Okay, so but for something that hasn't been patented at this point, and I'm not sure of how patentable it is, especially because it's been in presentations and whatnot. Presumably, we still want to assign the creation of that idea. Is that?
Yeah. Us corporate lawyers don't have quite the brain power that the engineers do. So how I would characterize it is like whatever it is, patentable or otherwise, the way we would think of it in kind of the corporate transactional perspective is whatever the ultimate IP protections that are or are not applicable, it's kind of a simple thing that says, I hereby assign to the company essentially any and all intellectual property rights related to my services or work, with or for the business. And I mean, it could be a single sentence that says just that. I hereby assign to the company ending all intellectual property rights related to the business. You get into more detail. It might, and in a more, lawyerly drafted document, it might say, including but not limited to processes, patents, know-how, trade secrets, information. I mean, it can be very broad. I think that without getting too into the weeds on what is or isn't patentable, a general blanket IP assignment is probably good for basic purposes. One thing to be careful about, if it's simply from a class among undergraduates, for example, you're probably unlikely to have much of an issue. But what happens very often in the university context, if you're working with a professor or a graduate student, sometimes their work related to class, if they're employed by the university, there's a good argument that the university might have its own claim to at least some portion of the IP. That's not something we'll fully tackle in a session like this, but if you're working with professors or grad students, you might need to actually work with the university tech transfer office to potentially get a license to the IP. That's a bit of a technical thing, but just keep in mind, if you're working with university personnel, the university, and it's true for, and it's not just CU, there could be university claims on the IP, and you have to deal with the university.
Okay, I would imagine that probably applies to us in some sense, but
it often does if there's grad students involved or professors involved.
yeah, we're all grad students, so.
Yep.
Yeah, that sounds like
And I will say, Graham, generally speaking, at CU, if it comes somehow out of a lab, the university is going to have some ownership. If it's just a class, it's not necessarily out of a lab, then you're a little safer on that.
The class had lab in the name, so I don't know.
I mean, yeah, and CU has a very robust tech transfer office. I don't know if anybody here is from the tech transfer office tonight, but they have resources you can talk to as well.
Okay. Can we broach that later if we get traction?
Yeah, I mean, you can, there are, I mean, again, from a patent point of view, there's at least in the US, there's a 1-year grace period between any public disclosure, which, in a class presentation, for instance, would probably be a public disclosure to file any kind of patent. That protection doesn't exist in most of the rest of the world. That's usually just the US.
Yeah.
And Graham, at this point, why don't you shoot me an email after this, and I will connect you with someone over in Venture Partners that does all the tech transfer stuff, and that way we can make sure that you're all good.
Okay, thank you. That's Dan, right?
Yes.
Yeah, right.
Hello everyone, my name is Alejandro. This is more of a question about intellectual property and corporate, and sort of the corporate structuring of everything. So for me right now, I sort of run a company that handles all of my music, intellectual property, name rights, name, image, and likeness, and everything. And that company is solely just for me. And so the company that I'm making for the purposes of New Venture is an actual overarching record label that's going to be distributing everything that I put out via my company right now. So how would you go about doing that? I don't particularly want the bigger label to sort of acquire my label, because it would sort of be, I'm using air quotes here, conflict of interest in my mind. But I want to make sure that I'm structuring it in a way that's sort of like, I guess, sustainable for the future and as least complicated as I can possibly make it.
And is the bigger label going to own the company you have now, or no?
No, it'll just be a contract basically assigning the rights on an exclusive manner to my name, image, and likeness, my music, intellectual property, and stuff like that. Probably for a certain amount of time, maybe like 2 to 5 years, and it'll just go on a renewing basis until one of us decides to cancel the agreement.
Yeah, so that's a license, right? Your first company is licensing the IP to your second your company. Essentially, is what's going on.
Okay.
Yeah, that typically, we need more than 60 seconds to answer that one, but you can kind of think of it like, if you own two separate businesses, like, one's music creation and one's a bigger, music business, you can keep them separate. You don't have to necessarily combine, but I think the details would have to be unpacked a little bit more to make sure we're getting the goal right.
Okay. And then just on sort of the employee ownership aspect, I do plan on allocating part of my stock base to employee ownership to try and draw people to come and work for the company. So in taking on co-founders, I don't make any money right now. So the only way I would be able to pay them is through equity in the company. And so I was just wondering how I would go about doing that in like, I guess the most like humane and like equitable way possible that I could in sort of the situation that I'm in.
Yeah, there's kind of two different flavors to that. The most simple, cheapest way is you just grant shares of company to your co-founders or the people you hire. Say, look, I can't afford to pay you, or I'm paying you below market, but here's 500,000 shares. You own 15% of the company. That's the best we can do. So that's part of setting up documentation, whether it's an LLC or corporation. You can set up your equity ownership among you and the people you want to bring on board, and using kind of standard corporate documents or LLC documents to make it happen. A separate version is an actual employee stock ownership plan, a little bit more structured, a little bit more geared towards particular benefits to employees, that is a little bit more involved than simply just being a direct share owner. There can be some kind of pros and cons to either approach depending on your goals. I think many startups start out with just issuing shares to the founding team, but the ESOP thing is another way you could do it.
I just wanted to add too, in the tax credit that Matt mentioned, that can come into play with a company that's only been in operation for a year. So even if you've had this underway and you want to make those kind of moves, definitely keep that tax credit in mind, because that can go to offset any of the legal costs or any technical assistance you'd want to use to actually make that shift. So you don't have to be far along in the company to potentially take advantage of that funding.
And then this last one is just from Joel's iPhone in the chat. It says, can you reiterate when non-disclosures are a good idea to pursue and when they can be a hindrance?
Yeah, the rapid answer is investors don't sign NDAs. If you go to an investor and say, I'd like you to potentially invest in my company, before I tell you about it, will you sign this NDA? You're usually just asking to not have a meeting. So the short answer is investors talk to so many different kinds of companies and entrepreneurs. They don't want to deal with NDAs. If you're concerned that the particular investor you're going to talk to is going to steal your idea, you shouldn't be talking to that person in the first place. In other situations, talking to a potential supplier, manufacturer, developer, vendor, commercial kind of relationships, not investors, but like a kind of a commercial type situation, it's very common to say, hey, we're interested in talking about doing this thing. Before we kind of look under the hood and share some details, let's sign a two-way NDA so we each keep things confidential. That's a pretty good way of looking at it.
Yeah, and it's and that NDA with particularly with vendors and things like that, when you're like say you're having somebody design or build your invention, an NDA can protect you. That can protect you from starting the 1-year public disclosure clock in the US. So that if you're under an NDA, that's not a public disclosure. So then you're not starting that 1-year clock, which is important.
Fantastic. So we are at time, and I want to be respectful of our speakers' time. So number one, thank you all for being willing to help us out and shed some light on some of these very difficult and tricky aspects of starting a company. And as I said, the contact information is in the chat for all of our speakers here today. So please feel free to reach out if there are other questions that you have, or other questions that pop up. Again, thank you all for coming, and Ventures, be on the lookout for an email coming from me soon about next steps and what's happening on future workshops. Thank you, everyone. Have a great night.
Thanks,
Thanks, everybody.
Bye.